Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been some discussion, some speculation, whether if Richard Allen, who is the petitioner in the matter styled as Allen versus State of Indiana, is successful in getting relief from the appellate court, will Judge Frances Gull preside over the case upon remand. By way of background, Mr. Allen was arrested and stood trial before Judge Gull and made certain rulings pre-trial and also certain rulings during the trial that Mr. Allen is challenging on appeal as constituting reversible error. He wants one of two things. He wants his convictions thrown out of court, or in the alternative, a Franks hearing. Mr. Allen requested a Franks hearing. That was denied. That is where a defendant brings forward evidence sufficient to show that there's a major problem with the warrant affidavit, the affidavit of probable cause that was relied on by the court to issue a warrant in the case, that defendant should be granted an evidentiary hearing. Frank's hearing is named after a famous Supreme Court case called Franks versus Delaware. At this time in the appellate proceedings, the briefings are closed. Mr. Allen filed his appeal last year, spring of 2025. The briefings, the initial brief on the merits that he filed in December of 2025. The response in opposition to any relief being granted to Mr. Allen on appeal, filed by the state of Indiana in March of 2026, and the reply brief that Mr. Allen recently filed, replying to the response and making one last argument that there is reversible error here, that the conviction should be thrown out, or in the alternative that he should be granted a Franks hearing. The briefings are now closed because those three filings have been submitted. They are on the record. However, what Mr. Allen has done is on April 27th, he served a motion for oral argument. He has asked for oral argument before the appellate panel, who will be making the ultimate decision as to whether the decisions of the lower tribunal should be affirmed, which is what the state is asking, or if there's reversible error here and Mr. Allen is entitled to relief on appeal, which is what he is asking for. A review of the docket in its May 5th, 2026 reveals there has been no response in opposition to oral argument as of yet by the state of Indiana. So at this point, we're looking for a ruling by the appellate court, whether granting or not granting oral argument. If they grant oral argument, then this would delay the final ruling until after oral argument occurs. Then the appellate panel would thereafter render their ruling. If oral argument conversely is not granted, then the only matter that remains would be a ruling on the merits. Returning to the question that many have been discussing, will Judge Gull still be the trial court in the event that Mr. Allen is granted relief? It depends. It depends on when any reversal and remand would happen. Let's just say, speaking figuratively, there's no way to know how the appellate court is going to rule. But let's say they throw out his convictions and remand for a new trial. Judge Gull has already notified the courts that she is retiring from the bench on December 31st, 2026. A ruling is not expected from the appellate court for months whether or not oral argument is granted. So depending on when, if he is granted relief, any such relief would be remanded to the state court, would then lead to the issue whether Judge Gull could entertain the matter through retirement time, or if another judge would need to be assigned. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.